People feel like their rights to free speech and freedom of association are being stripped away by these new risk-based hate laws. But here's the uncomfortable truth. In Australia, you never actually had those rights in the first place. We don't have a constitutional right to free speech. We don't have a constitutional right to freedom of association. What we actually have are freedoms that exist strictly on permission, not as rights as guarantees. And that is why these new laws matter. Not because they're shocking, but because they are perfectly lawful under our current system. Think of your rights as locks on a house, protecting your way of life inside your home. In Australia, your house was never locked, so you can't be surprised when someone eventually walks through the front door. Today I'm going to show you how these new laws are actually going to affect you, not how the politicians are selling it to you. But before we get into just how powerful these new laws are, let me know in the comments what rights you would like to see if we could have them. And subscribe to make sure you don't miss more of these explanations of the system that you live in and how it affects you. Most reporting on these new laws has been dangerously superficial. They talk about hate speech versus safety. But under the hood, something fundamental has been broken. Traditionally, the law acts like a courtroom drama. You have a crime, an investigation, a trial, proof, and then punishment. But these laws have killed that sequence. The new model is risk, intervention, consequence. We're moving from a system based on what you did to a system based on what somebody thinks you might do. In this video, we're going to walk through 10 specific ways your life has now changed. We're going to look at how your citizenship has become an ankle monitor, how the courts have been sidelined, and why independent journalists, people like the ones you watch on this platform, are more at risk than the mainstream media, and who's immune to these laws. And stay with me until the end, because I'm going to explain exactly how legislation like this can be repealed. So let's start with jurisdiction. Most people think the law works like road rules. You leave the country and you're under a different system. That does not apply to these laws. Parliament granted them what's called extended geographic jurisdiction, meaning they now follow you overseas. So here's the simplest way to think about it. Your citizenship is no longer a speed limit that applies to the road that you're on. It's more like an ankle monitor that you wear everywhere. If you're an Australian citizen, these new laws mean that what you do in London, who you interact with in Bali, or how you support overseas organisations online while sitting in your own home can carry criminal consequences. The law is no longer asking, where did this happen? It's asking who did it. This turns citizenship into a permanent legal tether. It's not something you step in and out of. It's a liability that you carry everywhere all the time. In the old world, the state had to prove that you committed a crime before they could punish you. Now, consequences can arrive before guilt is established, before a trial takes place. In fact, there doesn't need to be a trial at all. The new system works more like a no-fly list. You don't get banned from flying because you were convicted in court. You get banned because authorities decide you might be a risk. You find out after the consequences have landed, and then, and only then, can you try and challenge it. Groups can now be listed as terrorist organisations or hate groups without a single member being convicted of a crime. Once that listing happens, criminal offences attach to it. Surveillance powers activate and visas can be cancelled. And no jury and no judge decides this. The key question has shifted from did you do it to do authorities think harm might occur? That is a predictive system, not a judicial one. So people still imagine judges as the gatekeepers of serious legal power. That mental model is now outdated. So who decides whether a group should be designated? Well, under this regime, the biggest decisions happen inside government offices, not inside courtrooms at all. Think of the courts as the brakes and the executive government as the engine. Courts slow things down. They test evidence, they force justification, but under these new laws, the executive moves fast, acting on internal assessment without any breaks at all. The listing of the group, that's an executive decision. The triggering of offences, an executive decision. The cascading consequences, automatic. All of this happens without a judge being involved. Courts don't disappear, but they arrive late, and they arrive after the damage is done. This law isn't about whether courts exist, it's about whether they control the first move, and they don't. Traditional criminal law punishes conduct. It punishes what you do. This framework punishes proximity, closeness. It punishes who you're near. Once a group is designated, and remember, this could be any group, Your exposure comes from your connection to it. Membership is enough. Helping is enough. Recruiting is enough. And sometimes what they've called an informal membership, which is incredibly vague, is enough to trigger a visa cancellation. It's no longer about crossing the line, it's about standing too close to it. You don't need to commit violence. You don't need to intend harm. If you're in or associated with the network, you're liable. But James, what about the implied freedom to political communication? That is a fallback people reach for when they sense something is wrong. I'm not going to sugarcoat that. Here's the reality. The implied freedom of political communication is not a personal right. It doesn't belong to you. It does not protect speech like people think it does. It is a limit on Parliament's power and nothing more. And it exists only to the extent necessary to keep the system of representative government functioning. That's it. And critically, it does not protect association, membership, support, networks, or proximity, all of which are subject to these new laws. So let me say the quiet part out loud. The implied freedom doesn't mean Parliament cannot limit speech. It absolutely can. The implied freedom means that Parliament has to have a proper reason when it does. And with these laws, Parliament's given itself that reason. So once a group is designated, the law no longer cares whether your association is political, expressive, or ideological. It treats the network itself as the risk. And at that point, the implied freedom doesn't operate as a shield, which means the implied freedom of political communication is not a safety net. It's an argument that can be raised after the consequences have already landed. So when people say the implied freedom will protect us, what they really mean is, whether they know it or not, I hope a court steps in later. But hope is not a right, and delay is not a protection. And that is why association becomes liability under these new laws. Because once the law is built around networks and risk, not people and actions, individual intent, political purpose, and expressive justification all come second. Now here's something else that needs to be clarified, because some people are getting this mixed up. I've heard people say that journalists can still report on these issues. It's true, but it's incomplete, and it's certainly not a blanket rule, because the law doesn't protect speech. It protects recognized speakers. Think of it like a press pass. If you're inside a major institution like the ABC, News Corp, SBS, 9 News, the doors automatically open. You have a shield. But if you're independent, if you're a YouTuber, a Substack writer, a citizen journalist, and you're explaining the same facts, but you're doing it without the same protections. For professional journalists, explanation is assumed to be reporting for the public interest. But for independents, that same explanation can be reframed by the state as assistance, advocacy, or propaganda. And that's a problem, because it creates a serious imbalance. It's not censorship by ban, it's something worse. It's censorship by risk. So here is where the mask really comes off. Under this legislation, the law doesn't say this conduct is wrong. It says this conduct is wrong unless it's done by the government, with the government, or under a government agreement. In other words, the government is immune. So let me explain how this is going to work using the law exactly as it exists now. Imagine a group overseas is designated under this law. If you provide support resources such as donations or sign a petition connected to that group, you can be committing a serious criminal offense. Remember, this doesn't have to be a big organization. It just has to be an organization that the government declares, either due to political activist pressure or on their own, a hate group, which is, again, poorly defined. But if the Commonwealth does the exact same thing as part of a government program or authorizes somebody else to do it, it is explicitly not an offense. Nothing about the conduct changes. Nothing about the outcomes changes. Nothing about the hate group changes. The only thing that changes is who is allowed to do it. And at this stage, the government, or somebody working with the government, is the only person who can do it. So that tells you everything you need to know about the nature of this new law. It isn't judging actions as inherently right or wrong. It's not judging support of a group as inherently right or wrong. It's allocating permission. Who is allowed to and who isn't. And once criminal law works that way, it stops being a moral criminal boundary and becomes a licensing regime. Are you licensed to support a group? So if you're authorized, you can act. If you're not, the same exact conduct can put you in prison. One label now activates multiple systems at once. In the past, different areas of law were treated like different areas of law. Now they're being integrated. So if you get hit with a criminal listing, it automatically carries over into surveillance law. It automatically carries over into migration law. There is no fresh test. It's like pulling a fire alarm that doesn't just make a noise, it locks the doors, deploys the camera, and calls immigration enforcement. All from the one trigger, which is not activated after a trial, but instead of one. So this is how power concentrates quietly. You don't pass 3 separate powerful laws, you change one definition and let it roll through the entire legal ecosystem like dominoes. Intent used to be at the center of criminal law. Mens rea, the guilty mind. You had to mean it. But now, intent is optional. So we're seeing a shift towards recklessness, suspicion, and risk. These are much softer, more flexible standards. And here's why that matters, because when the standard is recklessness, you don't have to want to cause harm, you don't have to intend to cause harm. The prosecution just has to show that you should have been aware of a possibility that someone else might interpret your actions as harmful. When people don't know where the line is, they stop walking anywhere near it. That is, intentionally or otherwise, behavioral control. It chills free speech because the risk of being reckless is simply too high to take. Time used to close the book. You served your time, or the event passed, and it was all over. But with these new laws, the book stays open forever. Past statements, past associations, and past conduct, things you did 5 or 10 years ago, can be used to justify present decisions and future decisions regarding your risk. Think of it like a permanent file that never gets sealed. The question the state asks now is, what does your past history suggest about your future? And do we think that it is a risk? This is not punishment for a past crime. That's profiling. It means that you can never truly be cleared because your history is always available to build a risk profile. So yes, this law is retrospective. Yes, it applies to things that you've said and done in the past. Yes, you need to be careful now. And finally, the sequence of enforcement has reversed. Actions come first and justifications come later. Items are seized and conduct is stopped. Restrictions are imposed and then you get to argue about it in court. It's like being arrested and told, well, we'll work out later whether what you did was actually illegal. That reversal of due process matters so much more than most people realize. So people want to know, and they have been asking, how does this get reversed? How do you repeal it? Is it permanent? And the answer is no. No law is permanent, but repeal is always difficult. The High Court can't just strike these laws down simply because they infringe on speech or association. Remember, we don't have those rights. The High Court can only strike them down if they breach a specific, narrow text of the Constitution, which is historically very hard to prove. So to repeal this, you don't need lawyers. You need a new parliament. This is the natural outcome of a system with broad parliamentary power and no entrenched rights for its citizens. Remember, with no rights acting as locks on your front door, at any point, people can enter your home. And much like unwanted visitors, the government passed this legislation very late in the night. So if you want to understand the system that you are actually living under, not the one they tell you about on the news, make sure you subscribe to this channel. I'm going to keep breaking down these laws so you aren't caught by surprise. And it's not just the big stuff, it's how you can interact with police and what actual rights you have in those interactions. And if you found this valuable, share it with someone who thinks their rights are guaranteed. Wake them up. I'm James Glissan, and I'll see you in the next one.